Building upon the concept of the special agency relationship in property management, it is essential to understand how Arizona law formally defines a property management firm and the rental agreements they administer. These definitions shape the professional and legal framework under which property management operates and clarify the responsibilities of both the brokerage and the licensees involved. The Arizona Department of Real Estate, ADRE, enforces these definitions through ARS Section 322173 and related sections of Title 32, Chapter 20. A property management firm is a licensed real estate entity or brokerage that engages in managing income-producing property on behalf of an owner for compensation. This definition is broad, encompassing a range of activities that include collecting rents, negotiating leases, coordinating maintenance, hiring contractors, and enforcing lease terms. Under ARS Section 32-2174, only a licensed real estate broker or firm may engage in property management activities, and any licensee performing these duties must operate under the supervision of a designated broker. The law emphasizes that property management is not merely clerical or administrative. It is an activity that directly involves fiduciary responsibility and financial trust. For example, a property management firm in Scottsdale that oversees 50 residential units for various owners must hold a valid Arizona broker's license. Its designated broker is responsible for ensuring compliance with all applicable laws, including maintaining a trust account for client funds under Arizona Revised Statutes, Section 32-2174. The firm's employees or salespersons may carry out daily management tasks, but ultimate accountability rests with the designated broker. If one of those employees mishandles rent payments or fails to properly document a tenant deposit, the firm and the designated broker can both be held liable for violations of ARS Section 32-2153, untrustworthy conduct, and ARS Section 32-2174B, improper handling of client funds. The property management firm's authority is always established through a written property management agreement, which clearly outlines the firm's role as a special agent. Without such an agreement, any management activity performed by the broker or firm would be considered unlicensed or unauthorized under ARS Section 32-2173A. The agreement typically specifies the property address, term of management, responsibilities, compensation, and accounting procedures. It also defines the handling of trust funds, repair authorizations, and tenant interactions. A rental agreement, on the other hand, is a contract between a property owner or their property management firm and a tenant that establishes the tenant's right to occupy a property in exchange for payment. In Arizona, rental agreements are governed by the Arizona Residential Landlord and Tenant Act, ARS Section 33-1301 et SEQ, for residential properties. The rental agreement is the primary document defining the terms of possession, payment, maintenance responsibilities, and legal rights of both parties. A rental agreement can be written or oral. However, written agreements are always recommended, and in most cases, legally required under the Statute of Frauds, ARS. Section 44-101, open parenthesis, 6, close parenthesis, which mandates that leases exceeding 1 year must be in writing to be enforceable. This ensures clarity in expectations and provides an evidentiary record of the terms. For instance, if a property manager leases a home for 2 years at $2,500 per month, the agreement must be in writing and signed by both the owner or their agent and the tenant. Key provisions in a rental agreement include rent amount and due date, duration of the tenancy, security deposit amount, maintenance responsibilities, late fee policies, and procedures for termination or renewal. Arizona law under ARS Section 33-1321 restricts how landlords and property management firms may handle security deposits, requiring that deposits not exceed 1.5 months' rent and that they be returned within 14 business days after the tenant vacates, less any lawful deductions. In the property management context, the rental agreement serves as the working instrument through which the property management firm fulfills its special agency duties to the owner. The firm is responsible for ensuring that all leases comply with Arizona law, that disclosures are made properly, such as lead-based paint or pool barrier notices, and that tenant funds are handled in accordance with trust account requirements. Failure to properly draft, execute, or manage rental agreements can lead to serious legal and disciplinary consequences. For example, if a property manager neglects to include the owner's name and contact information in the lease, or if the firm collects a security deposit but fails to hold it in the designated trust account, ADRE may consider these violations of ARS Section 32-2153, A3, and ARS Section 32-217. An illustrative case is Arizona Department of Real Estate v. Sibley, 2002, in which a broker was disciplined for failing to maintain accurate trust account records for tenant deposits. The court affirmed ADRE's decision, highlighting the broker's duty to act as a fiduciary and maintain full transparency in handling client and tenant funds. Review summary. A property management firm is a licensed brokerage authorized to manage properties on behalf of owners, while a rental agreement is the legally binding document that governs the landlord-tenant relationship. Together, they form the backbone of Arizona's property management structure. The firm operates under the authority of a written management agreement and must adhere strictly to statutory requirements regarding trust accounts, disclosure, and fiduciary duties. Rental agreements must comply with the Arizona Residential Landlord and Tenant Act and the Statute of Frauds to ensure enforceability and protection of all parties involved. Discussion prompts. Why is it important for a property management firm to have a written management agreement? Answer: it defines the scope of authority and fiduciary duties, ensuring compliance with ARS Section 32-2173. How does the Statute of Frauds apply to rental agreements? Answer: leases longer than 1 year must be in writing to be legally enforceable under ARS Section 441016. What are the fiduciary implications of mishandling tenant deposits? Answer: it can result in license suspension or revocation for violating ARS Section 322153 and ARS Section 322174. Closing remarks. Defining a property management firm and rental agreement is foundational to understanding how Arizona regulates property management activities. These definitions clarify the roles, duties, and legal limitations imposed on brokers and licensees, ensuring ethical conduct and transparency in property management operations. Adhering to these standards protects property owners, tenants, and the reputation of the real estate industry as a whole.